Excuse me.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the Appeals Court. My name is Peter Sachs. With me are Justices Catherine Hand and Rachel Hershfang. We'll be your panel on all 5 cases this morning. We usually take a short break after the 3rd case. As you know, each side has 15 minutes to argue. There's no rebuttal. You don't have to use all of your time if you don't need to. We've read your briefs. We're familiar with the facts and the procedural background and your arguments, so I would urge you to skip over a general introduction and just jump right into what you think are your most important arguments. The timer will replace our court seal once your argument has begun. When it's read, your time is up. Be assured that we'll consider all of the arguments in your brief, whether you've made them orally or not. With that, I will call the first case, number 21P355, Commonwealth versus MONDEL Johnson. Attorney DeMaio.
Thank you. May it please the court. Christopher DeMaio from MONDEL Johnson. I'm going to focus this morning mainly on the arson related issues, and then if I have time, I'll circle back and talk about the jury selection. There's 2 issues or 2 sub issues for arson. The first is sufficiency of the evidence as to malice, and the second is sufficiency of the evidence that this structure, 36 Restful Lane, was a dwelling house within the meaning of the statute at the time it burned down. As to malice, the burden on the Commonwealth is to prove that Mr. Johnson took actions that had a plain and strong likelihood of setting the house on fire. Now, certainly in the light most favorable to the government, there was evidence from Matos, the key witness, that he was throwing newspaper that was on a fire in the house, primarily in the kitchen. It seems that some of it, at least some of it, was on fire when it hit the floor. She said she was lying on the floor for part of the time, and some of it landed pretty close to her. And I quoted that in full in the blue brief, and that's pretty much it. Now, is it a bad idea to throw burning papers inside a structure? Of course, no one would argue that, but the question is there a plain and strong likelihood of setting the house on fire? And
it doesn't have to be the whole house, correct? It can be a portion of the house?
That's correct. That is correct.
So even setting a fire in a patch of the kitchen floor would suffice?
No, well, I mean, on fire means on fire. I mean, I believe the cases say on fire or charred, which means that it was blackened by fire. So I would submit the devil is kind of in the details here. If you're throwing little bits of paper that are burning out and embers are mostly embers when they hit a tile kitchen floor, then you really don't have a plain and strong likelihood. If I light the entire Boston Globe on fire and throw it under a wooden kitchen table, than I have. So it really depends, and details are what we don't have here because this witness either wouldn't or couldn't provide them by the time of trial. And I think you see that when you look at some of the other cases, that the published cases deal with people setting fire to flammable things. In Pfeiffer, it was a stack of laundry. There's another case where someone sets fire to drapes or curtains. And you just don't have that here. And I would submit that the Commonwealth can't really fill that gap now with reasonable inference under Lattimore, which they can sometimes do. You really have to kind of
Attorney DeMaio, if I may just add one more fact that that I think is germane to the discussion. I think there was evidence that there was a bottle of cooking oil on the table, and that when the victim woke up, she was coated in something slippery. Were the jury allowed also to infer that the cooking oil may have been involved in whatever it was that your client was trying to do?
I'm not, that's a tough one because the judge directed a verdict on that particular count, but I don't know that.
Well, the judge directed the verdict based on a mistaken belief that there had been no testimony. And so your client got the benefit of that, but if you go back and look at the transcript, there was the testimony about the oil. So I'm not sure how far that gets you.
Yeah, yeah.
Um,
Even so, I don't, I agree, Your Honor, that's one more factor in it. But again, if she said it landed next to me in the oil or close to the oil or something, but really, I would submit what I pretty much quoted the whole thing verbatim in the blue brief, and I submit when you put that all together, you don't get malice.
Was there also evidence that some of the pieces of newspaper were thrown in the living room?
I think she may have said that at one point, but then there's not a lot of evidence what was in the live. I mean, if we knew there were rugs and, you know, it was very undeveloped, I guess is my point, and it's relying quite a bit on conjecture at this point to fill that in. On the issue of whether this was a dwelling, as the court knows, there'd been a storm, a tree had fallen on the roof. There's a hole in the roof. A town official orders the house vacated, and the gas is cut off, the electricity is cut off, the water's cut off. So it's winter in New England. You have no heat, no light, no flushing toilets, no running water. It wasn't habitable as of that day. Now, I know the Commonwealth argues, and it's correct to argue, that a house can be unoccupied and still remain a dwelling. So if I go off to Florida for a month or two in the winter and I stop my mail and cut off the electricity, my house remains a dwelling house, notwithstanding. But this isn't that case.
Attorney DeMayo, and I'm sorry to interrupt you, but are there cases that say even a condemned building can be a dwelling house? And this building was not condemned. It was that the utilities were shut off, not cut off, if I understand the testimony correctly. Is that?
Yeah, that's correct. Well, the only case that talks about condemned is an unpublished case, the Davila case. And that case is distinguishable because the person was actually living there with his family. So I think the point of the panel there was you knew people were using it as a dwelling because your own family was there along with other people, and so that's kind of a special circumstance that we do not have here. I'm not entirely sure.
As we do here, what do you make of the fact that there were indications that the owner intended to return? The hole in the roof was covered by a tarp. It wasn't left unattended. He had been out for approximately a week, if I recall correctly. He'd left belongings, including stereo equipment. There was food in the fridge.
Right.
What do you make of that?
I make that it hadn't been condemned, but I also would point out that we don't know what was going to happen. The Commonwealth suggests because it wasn't condemned that it's just a matter of patching up the roof, but that we don't know that. I mean, because it never had time to get inspected. Perhaps it was just a matter of patching up the roof. Perhaps it was a lot more damage. Perhaps there was structural damage. Or all you can say for certain that is, as of the day of the fire, it was uninhabitable, and for the indeterminate future, it was going to be uninhabitable. And maybe it would have been fixed up, or maybe it wouldn't have. But it's not like a temporary, like we can just say, I went to Florida and I'll be back in a month and it'll be fine. The record is not clear here on that point.
Well, it doesn't have to be fine in order to be capable of occupation, does it? I mean, as long as someone can sleep there and sleep in a bed, which I think it's fair to presume was there because all Nazarian took with him supposedly were some clothes and his computer.
Yeah.
Is that enough? I mean, do
No.
we need electricity, running water, gas, whatever?
No, it needs to be capable of being occupied as a dwelling. And that's, I think in the DeStefano case, they talk about carrying on life activities. Sleeping certainly part of that, but I mean, you can't cook, you can't take a shower, there's no flushing toilets. It wasn't under any stretch of the imagination a dwelling. And with regard, I'm not sure that I agree that Davila was correctly decided. It's unpublished, but I quoted the code in my blue brief. It says, as a matter of law, if he can only order the house vacated if it can't be safely habited by a person.
But did he order the house vacated? The testimony was the town official said people, I'm looking for no one should be there until the roof was fixed. The home was not to be lived in until the roof was fixed. Was that an order? Was that a determination of noncompliance with the code? I mean, the evidence about that was fairly sketchy too.
It was kind of sketchy, but that's what I took it as that he had to get out of the house and That's why he secured it and left when he did, and did the things that he did. Now, the Commonwealth has an alternate argument, which, but anyway, to get back and answer the question, this was not livable. There are cases where there's no electricity. There might be cases where you're missing some amenities, but I don't know of any case where you don't have any utilities at all, no gas, no electricity, no water.
But I think, Attorney DeMeo, I think that gets to Justice Hand's point, which is that the utilities were turned off, not shut off. So I don't know what there is in the record on this. I presume, though maybe it's not fair to do so, that Nazarian was living in the house until it was inspected and he was told whatever he was told. Right? He had a tarp over the roof. He was living there. Then he was told, maybe you should get out, maybe you must get out. I'm not sure what the record is on that, at which point he cut off the utilities. So, I mean, just as when you go to Florida, which you have to stop talking about that, because wouldn't we all rather be in Florida right now, and you deliberately turn off your utilities for a month, that does not make your house uninhabitable. Right. So I think the utilities are a little bit neither here nor there to this discussion. It's really the tarp, the inspection, the tree damage. And it seems like he was living there with a tarp until he was told whatever he was told.
Well, that's the reason I think the utilities are relevant is because I think he was obliged to do that because there's a danger, and that's why he did it, and because it's going to remain in that status for the indeterminate future. It's the indeterminacy really what that distinguishes this from I'm going on vacation or I'm going away. We just don't know. We just don't know, and that's what kind of makes this case distinct from other cases. And we don't, and so it's hard to say that this could have been used as a dwelling on the night in question, given the state of the record, which was the Commonwealth's.
If I could just ask one more question about dwelling house, should we interpret this with the keeping in mind that the purpose of the statute, which I gather provides. Well, is the purpose of the statute to punish more severely the burning of a building in which people could be sleeping?
I think that's probably I don't know the history of this, but I think way back when it was a capital crime. That's why you have 266 section 1, which is dwelling houses, and 266 section 2, which is pretty much everything else. So I'm guessing that's why that's the case. So is it helpful for us to look at whether people could have been sleeping there or whether people could have been staying there in a way that would have perhaps allowed them to have been taken by surprise if the house caught on fire and been unable to? I mean, I think it has to be read in conjunction, I would say, with 266-2, which I printed out, which covers everything else. And they give by an example: church, courthouse, townhouse, college, academy, jail, which seems kind of cruel. Jail people have to, banking house, warehouse, store, and so on. So I don't think that the people could be working late in any of these, and yet they're excluded by virtue of the statute. So I think it's a criminal statute. It has to be strictly construed, and it's meant to cover actual houses, or if they're not being occupied at that moment, clearly capable of in the determinate future being used as a house, and not just slept in, but again used as a dwelling, other life activities, the bathrooms work, kitchen works, and so on. I have just a couple minutes left. I did want to say a word on the jury selection, since I brought a whole new trial motion on it. But I think my point, the point I really want to make on the jury selection is that when a prospective juror expresses some bias for or against a certain class of people, and a judge wishes to rehabilitate that person, I don't think it should be entirely a matter of discretion how that's done, because the statute 234A, section 67A says that the person has to be questioned with respect to the bias. So if I say if I'm a prospective juror and I tend to believe or disbelieve certain races, religions, sexes, professions, or whatever, and the judge wishes to rehabilitate me, It's not enough to simply say, but Mr. DeMayo, can you be fair? What I want to know is, can you be fair and impartial? Because if I say, sure, Judge, I can be fair, I haven't said anything to negate the thing I just said a moment earlier that expresses the bias. And a lot of judges, I mean, I'm sure Your Honor see a lot more of this than I do, but a lot of them do it, I think, the right way, which is to say, I need you to tell me that you can set aside that bias you were just talking about a moment ago and treat people of this race, religion, profession, whatever, the same as that you would any other witness. Can you do that?
What is the right way to phrase the question in light of the SJC's decision in Commonwealth versus Williams in 2019 regarding the woman who expressed her belief that the justice system was rigged against young African-American males? And the SJC suggested that maybe it's not the right thing to do to say, can you put aside your life experiences? But there's a different phrasing that's suggested, and I'm wondering what you think the right question would have been here.
Well, I wouldn't say life experiences. I would just say, I mean, her father was a police chief, so I would just say, I appreciate your father was a police chief. You've just said you tend to believe police a little more, if that answers my question. But I need, if you want to sit as a juror on this trial, you need to treat everyone without any presumption that they're more credible or less credible, even, and that includes treating police the same as you would any other witness. Can you do that? And then if she said, yes, I can, I think I can do that, then at that point, the discretion would kick in. And if he says, yes, I heard her and I believe her, then he gets, that's a strong presumption that he didn't abuse his discretion. But the actual message to be conveyed to the person can't just be, but can you be impartial? We would submit, and that's what we have here.
Just a sec, can I just ask one follow-up? I know
Yeah, and I've got one too.
Attorney DeMayo, if I understand correctly, that there is obviously the questioning of this one juror and the failure to strike her for cause is I guess I'd call it a proximate cause of the claim that your client has, but it's not, she wasn't seated, right? So really what we're talking about is whether the fact that it was required to use a peremptory for her caused an unfair disadvantage to your client. And I guess what I want to focus on in that regard is the evidence, or more precisely, the lack of evidence as to whether objections were made below and preserved about the use of all the peremptories. So as I read the record in the briefing, counsel did not ask for an additional peremptory, did not note during the trial that either of the later seated jurors was unacceptable or that he would have wished to exercise a peremptory on either of them but had none left, and did not in the subsequently filed affidavit articulate with respect to either of the two later seated jurors. By later seated, I mean after all the peremptories had been used, what was objectionable about either of those jurors. If I've got any of that wrong, please tell me. But if it's right, in light of that, where is the prejudice here?
That is, I believe that's all correct. The prejudice is that, notwithstanding the prejudice, I would say, I'm not sure that, I guess I kind of take issue with the question, because under the McCoy case, if you make an objection to a person who should be objected to for cause, and this again goes back to the statute 234-67A, I think he clearly objected to juror number one. He didn't say the word "I object, Your Honor," but he made a large fuss about her, and they called her back, and then he ended up striking her with his peremptory. So that was pretty clear. Now, certainly it would have been better from my perspective and Mr. Johnson's perspective if at the end of the whole impanelment, he said, and by the way, I would have used, and he didn't, and I tried to cure that with the new trial motion. But because he brought that to the judge's attention, I would submit that the prejudice is simply just in having to use up the peremptory. But it's not a case like the cases where there's no objection made at all, because when there's no objection made at all, as in the case the Commonwealth relies on, then you do have to show prejudice. And in that case, you do have to show an actual partial juror was seated. I'm not arguing that any of the jurors who were seated were partial. I'm just arguing that he didn't want to use up that. And it's true that by the time he filed that affidavit for me, he wasn't in a position to say, I remember I didn't like juror number 62 for whatever reason. He just said, and I think plausibly so, a lot of criminal defense lawyers use up all their peremptories, and that's all he was in a position to say, unfortunately. But
Can you explain to me how that affidavit makes sense and why it would, why he would use up all his peremptories, knowing that if he gets rid of some juror who he previously didn't use a peremptory on, he's got to take the next one up unless that juror is disqualified for cause. And so isn't it kind of buying a pig in a poke?
well, it could be. I mean, but you see people use up the peremptories all the time, and I guess that's always a risk. I mean, there is a risk when you do that. But I mean, the judge decided this on the papers without hearing from him, and the judge also he didn't say if you told me this, Attorney Madden, I would have given you another peremptory, but the judge really just reaffirmed, I think juror number 1 was okay, and decided it on the papers. So I don't know that we can.
Yeah, I guess what I'm asking maybe, and it put it differently, is did the judge have to credit the assertion that he would have used all his peremptories? Because is that a rational decision? I mean, doesn't it depend a little bit on how strongly you object to the remaining juror on whom you're going to use your last peremptory compared to the risk you could get somebody who's worse for your client?
Well, that's true. It only makes sense in conjunction with the attorney's other statement, which is I remember being not entirely satisfied with this jury, but I can't say at this point. I got that affidavit from him like 6 months after the fact, so he wasn't he was just trying to be honest. I mean, he didn't feign that he remembered. But if you take his dissatisfaction with the jury in conjunction with the fact that it's reasonable, I would submit, and not a pig in a poke if there's some people he'd rather not have. So.
Okay, thank you.
Thank you.
ADA Middleton.
Thank you. Good morning. May it please the court. Bridget Norton Middleton for the Commonwealth. The defendant has raised 3 issues on appeal. With the court's permission, I'll just start with the first issue, the juror issue, unless the court would like to start with a different issue. Here, the judge carefully questioned the jurors. He followed the governing law in terms of the questions to the entire venare. He called the first juror up. The judge immediately keyed in on her dad was a captain in the Hingham Police Department, which also isn't connected to this case. It's not a Hingham case. The judge questioned her about that. He gave counsel an opportunity to question. At the end of the first round at sidebar, the judge finds her indifferent. Counsel concedes that the juror said, I can be impartial. He said, I just don't believe her. Pointed out some things, and then the judge said, okay, I'll bring her back up. Judge brings her back up for a second time. And I submit to the court that the judge does a second time precisely what counsel and I think the court was indicating a judge should do. He asked her, with respect to a police officer, are you going to just believe whatever a police officer says? Or are you going to evaluate his testimony and make your own determinations? The juror responded, I can evaluate with response to other people's testimonies, I think.
What does that mean?
That she's going to evaluate each witness, I read that in conjunction with everything else. She said that she's just not going to believe a police officer because, as she indicated in the first go around at sidebar, when defense counsel asked her about whether she finds police officers credible, she indicated, well, I know some bad police officers. She did say, I tend to believe police officers. The judge brings her back up, questions her again, and asks her, are you just going to believe a police officer, or can you make your own determination? Yeah. And I read that.
I guess the statement itself doesn't make logical sense to me. I can evaluate with response to other people's testimonies, I think. Is there a typo in the transcript and she said something that was intelligible, or did she say something that's kind of unintelligible, and should the judge have followed up?
Yeah, my memory is, I've listened to this. My memory is that is what she said, because I think I would have noted it if she didn't. And it's not a perfect sentence. These are lay people up at sidebar in court. They get the judge is asking them kind of serious questions, and I think people try to do the best that they can. I read that, and I think she's trying to say to the judge, I can evaluate with a response to other people's testimony. So I will listen to both of them. It's maybe not how I would say it or you would say it, but I think the meaning of what the juror is trying to get across is there.
I think she meant to say with respect to, and just got the phrase wrong.
I think people are nervous in court. So, you know, and again, what I would point out here is the wrap up with counsel when the judge says, I'm going to find her indifferent. Again, defense counsel acknowledges. And I think you can take defense counsel's and the judge's read of what this juror said, that I know she says she can be impartial, but he just doesn't believe her. And so I think that's a good indication of what this juror came across like to the defense attorney and to the judge. The defense attorney is acknowledging that. And really, it's up to the judge whether he believes her or not. And on this record, does this record support the judge's findings? And I think on this record, it does support the judge's findings. So in the circumstances of the questioning here, I think the judge was well within his discretion to believe her and find her indifferent. I would just point out to the court, there's one additional case that has been published since this case came out. It's an SJC case. Last name spelled Aduayi by Justice Gaziano. It's a slip opinion, but they kind of get back into this, you know, what can the judge, whose discretion is it? He goes over a little bit of the judge's discretion. And this is a case where the counsel, you know, answers to questions by counsel. The gist of this case is answers to questions by counsel do not limit a judge's discretion. So jurors may say a couple of different things, but the judge listens to everything, and the judge's discretion is to decide what they credit and is there something in the record. So I think that case kind of broadens a little bit, because there have been some cases where defense counsels have, that I've cited even in my brief, where, you know, they want the judge to follow up where there was discrepancy with the juror, or the juror said this last word. I want to say it's a Kennedy case, the last thing the juror said. And I think the courts have kind of pulled back on that a little bit. And it's not the last thing that the juror said. It's not necessarily the one thing she might have said. It's, did the judge explore the issue? And is he satisfied with that juror in front of him making a credibility determination as they listen to it? Is that judge satisfied that this juror can be impartial? Then on appeal, does the record support that? And on this record, I think that it does. The equivocal responses, I've taken care of that, addressed that in my brief. If the court doesn't have any questions, I'll just move to the prejudice part of it. I think the court's keen on a couple of things that are important here. Defense counsel absolutely did object to this juror, and he lays out the record why he doesn't want this juror on, and he ends up using one of his challenges. But then there are, by my count, 6 jurors, the judge himself, after this juror sat, 6 additional jurors that the judge strikes for cause. Then at that point, there are 3 jurors that are seated with no objection by the defendant. And in defense counsel's affidavit, he doesn't get into, and on appeal, they don't get into, well, juror 55 did this and he would have struck her. There's not even any analysis in terms of, well, who are the jurors that were sat and were there any problems with the jurors that were sat? It's juror 55, 56, and 60. So there's no objection. And I think under the cases that I've cited in my brief at that point, that even if the court found that there was error in the judge not removing juror 1 for cause, that there's no showing of prejudice here to this defendant. I moved to
Is it plausible? Yeah, I'm going to ask you about the same issue I asked defense counsel about regarding the trial counsel's affidavit and his practice of using all peremptories. Does that make sense in your view?
I don't think I would do that.
That you would use a peremptory? Sorry?
I don't think I would do that. You know, I'm a prosecutor, so I have a little bit of a different calculus at trial, but if I were defense counsel, I think I'd want to wait to make sure, just in case that last juror came up, that I have a peremptory to get rid of them if I don't want them on the jury. Does that answer your question?
Well, so I guess my question is, would rational defense counsel make a practice of using all peremptories in every case? Or might the juror on whom the defense counsel is otherwise inclined to use the last peremptory be someone who's not so objectionable that it's worth the risk of taking the next juror up, unless that juror is disqualified for cause?
So in terms of whether it is an appropriate strategy choice of defense counsel is not an issue that we briefed. So I'm not a defense attorney, and I would have to think and read more cases to think, is there some advantage to that? What would be the reasoning for that? You know, as a prosecutor, you have a different calculus on that. But here, defense counsel, I mean, he knew what he was doing. He made the right objections. He made them clearly. He fought for this jury to be off. And it also can be that the last three jurors, that there is, as I said, appellate counsel does not make an argument delving into the transcript. Well, he would have seen these three jurors as problems with these jurors. So there's not even a real finding that there's some bias with or argument that there's some bias with these last three jurors. So if there's no bias in the last three jurors, even if the court were to say, well, maybe defense counsel shouldn't.
No, it doesn't have to be bias, right? I mean, it can be anything. I just don't like the way that the person looked at me.
But you're talking about prejudice. So you're talking
well,
about
no,
prejudice.
I'm talking about whether the trial counsel would have used that last peremptory. And all we have is an affidavit saying, I make a practice of it, but nothing more
Right.
specific than that. You're saying
Yes.
the transcript doesn't show any obvious bias remaining in the jurors who were on the panel, so that we
Yeah.
can believe that the peremptory would have been used for that reason, but it doesn't have to be biased. He can use the peremptory. Trial counsel could use the peremptory for any reason.
Yes, absolutely. But the point I'm making on that is to cases where defense counsel has said, well, there is prejudice to my client because I would have used my peremptory on juror 57. And some of the appellate cases they get into a little bit in their appeal or maybe the motion for a new trial. The problem with the jurors that were actually sat on the jury that weren't struck. And we don't have that here. There's no suggestion that there was a problem with one of these jurors that the defense counsel couldn't address. So it's just another layer of the analysis of why there is no prejudice in this case. Cases talk about that, like juror 57, I would have struck that juror. We don't have any of that here. So I guess the point I'm making is even if the court found, well, who uses all the peremptories, doesn't there really have to be a problem? Doesn't there have to be a juror on that jury where they look at them and say, well, here's the problem.
I suspect that if Attorney DeMeo were allowed to do an oral rebuttal, he might say something like, well, the prejudice is that the lawyer was not allowed to try the case in the way that the lawyer intended to and does try the case, right? That he said he uses all his peremptories as a matter of course. Had he had that additional peremptory, one of these last three seated jurors would have been subject to it for reasons that by the time he wrote the affidavit 6 months later, he just couldn't remember, but he does recall that he just didn't like them for some reason. And that is the nature of a peremptory, putting aside obviously improper use of peremptories, right? It's like, you're wearing a weed t-shirt and this is a marijuana case, or I don't like the way you looked at me, or I strike everybody from Cambridge, whatever it is.
Mhm.
So I suspect that might be his rebuttal.
And the only thing I would say on that is that the defense counsel, who showed himself to be capable during this trial, didn't even raise an objection to cause to any of these jurors. And I understand the nature of peremptories and it's different, but we're talking about prejudice here, and there was nothing that caught his attention to say, Judge, I would like this. And he was keen to that. He keyed in on that with juror 1. So in terms of the excited utterance argument by defense counsel, I would just point the court to the defendant's reply brief. Page 7 of the reply brief, the defendant argues, if the victim had been brutally and viciously attacked in the house to the point of losing consciousness and then awoke in the burning house injured and bloody with her clothes torn off, then this would indeed show a startling event that could give rise to a spontaneous utterance. That's exactly what the testimony was. So, I think there's enough here. The judge properly made that decision. The victim testified to that. The judge is entitled in the context of deciding whether something should come in as an excited utterance. The judge found exactly that she was under the sway of a startling and exciting event. So given defense counsel concedes that, I would move on to the last issue.
Let me ask you a question about that, if I may.
Yep.
So Matos exclaimed to Andrade, I believe, if I'm pronouncing that correctly, "Oh my God, there's a fire,"
Yes.
which suggests that she was surprised when she looked back over at the house at 37 Restful Lane and saw it was on fire. And then later when she goes to talk to Sanders and Johnson, she says the defendant lit the house on fire. And the defendant suggests that there's a contradiction between that, because if she was surprised when she was standing outside the Andrade's house and she looked back and said, "Oh my God, there's a fire," that suggests she didn't know that until that point. So how can she then go to the Johnson and Sanders' house and say, "Oh, the defendant lit the house on fire"? Either she was feigning the surprise outside the Andrade's, or she didn't really know that the defendant had lit the house on fire, and she was fabricating when she said that he did to Johnson and Sanders.
So it's interesting how that testimony came in. The Commonwealth objected. So who's on the stand is the police officer, and the defendant is trying to get in what Andrade said the victim said. So we have a police officer saying what Andrade said, and the judge objected. The judge sustained an objection to that and didn't allow it in.
And then it came in at the last minute, kind of
On
surprisingly.
redirect, on redirect, the prosecutor asked the officer what was, I think, about the victim's demeanor. And the officer said, well, how did Andrade say the victim looked? It was, it may not be exact wording, but he's asking what was her demeanor when Andrade saw her. The officer instead answers what Andrade told him the victim said. I don't think the judge has to credit that. He had already sustained an objection. It's double layer hearsay. Yes, it came in, and it's a non-responsive answer to a question. And yes, it came in, but I don't think the judge has to credit that testimony when he's making a determination for, whether evidence should come in or not. I think it's within the discretion of the judge to say that. The other thing I would say is, even if it comes in, the victim had testified that the reason why she left, she's bleeding. And this man's trying to help her. This man and his wife are trying to help her. She doesn't know them. She knocks on their door. What spooks her is they're going to call the police. And this is a troubled woman who does not want to be around the police for lots of reasons, maybe in her own life. And she gets, what she says is she gets spooked and she runs off. So in that context, even if the court were to credit that she said it, is she saying that because she's really startled, or she sees a fire and she just wants to get away from Andrade's house because she's afraid, she doesn't know where this defendant is? There was some testimony that maybe she thought she saw him outside and wasn't sure if she saw him. And I mean, she's half dressed, covered in oil, bloody, no shoes on, and she runs. Defense counsel indicates in his reply brief that there's no evidence that the victim ran to LaToya and Sanders' house. Defense counsel elicited that on cross with the victim that she ran. There's more than one place in the trial transcript. So
can I ask, and I know the light is red, but we gave Attorney DeMayo some extra time, so we'll give it to you. The trial counsel's affidavit in support of the motion for new trial says something about how Andrade had been a grand jury witness. We don't have the grand jury minutes, but did Andrade tell the grand jury that the madhouse had said to him, "Oh my God, the house is on fire"?
I'm not sure of that. I think that it was in the police officer's report. So I'm just not sure about the grand jury.
Huh. So what you said before, there's double hearsay, the judge didn't have to credit it, but what?
Yes.
I mean, if we knew Andrade had said it, are we not crediting Andrade, or are we thinking that the victim was fabricating when she said that to Andrade, or what's the?
It's hearsay, and there's lots of reasons why we don't allow hearsay into a trial, because it's not reliable. And here this is a police officer's memory on the stand of what a witness that he interviewed said the victim said at a fire. There's lots of room for that not to be reliable, and I think that's why we don't allow hearsay. And it did come in, but what came in is not that the victim, and this is being kind of picky, but what came in is not that the victim said that. What came into evidence is that Andre said the victim said that, and the judge can credit that for what it's worth.
Okay. So you want to take maybe 90 seconds to talk about the sufficiency issue, or you don't have to?
Just, the only one that I think that I would just is the adjacent to. I know that was an alternative argument in my brief, but I would point out to the court that the man shed, or whatever, the man cave, is 30 feet from the back porch of this house. Milne's, and there's testimony to that, Milne's house is 60 feet from Mr. Nazario's house. So as an alternative argument, even if the court were not to find that this was a dwelling house or find it's, but it's also adjacent to a dwelling house. I could not find any cases that, you take the plain meaning of adjacent.
Was that theory argued to the jury? And is it consistent with due process to uphold a verdict on a ground that wasn't argued to a jury?
I'm not sure that it needs to be argued to the jury, but the jury was instructed on that. And I think that satisfies due process. So the judge did instruct the jury on the different ways to prove arson. And that was certainly instructed by the judge. And the prosecutor went to some lengths. I can't recall if he specifically made that argument in his closing, but I would say to the court that he spent quite a bit of time describing the man cave and could you live in that? And was it charred? And, how far is the house and all the rest of it? So he certainly laid the factual foundation to make that argument, whether he actually said to the jury, alternatively, I want you to consider the adjacent argument. Now, as in a closing argument, you may not want to argue, you may put the evidence out there, but you may not want to give the jury that alternative. It's just as a matter of strategy.
If you're relying on the man cave, does there have to be a plain and strong likelihood that the defendant's actions in throwing newspaper on the Restful Lane floor would cause the man cave to burn?
No. The man cave, the burning of the man cave, it was charged as Restful Lane. So the burning structure has to be Restful Lane in my reading of the indictment. So we are at the point of the law that says a property. So he's burning a property. So is that property a dwelling house, Restful Lane? Is it a dwelling house under the law? Or is it adjacent to a dwelling house, which would be Mrs. Milne's property?
Gotcha. Okay.
That's the alternative argument.
Right.
With that, I would rest on my brief. Thank you very much.
Thank you both, counsel.
We are live and on the record.
All right, the next case this morning is number 21P704, Commonwealth versus Jason R. Robinson. Attorney Daniels.
Actually, Your Honor, I believe it's the Commonwealth's appeal.
Oh, I'm sorry. I apologize. You are correct. Attorney Bodwin.
Thank you, Your Honor. May it please the court, Nathaniel Bodwin for the Commonwealth. Before I get into the argument, Your Honors, I do want to acknowledge that the family of Mr. Wilson, the victim in this matter, are watching this live on the court's YouTube page. So in this case, the judge's ruling allowing the motion to suppress was in error because, as the case law regarding search warrants state, a search warrant should be considered as a whole. It should be considered in a common sense fashion, and it shouldn't be subjected to overly restrictive or hypercritical analysis. And I think the judge here was overly restrictive in her reasoning. That's why the Commonwealth is asking this court to reverse the order. I think a common sense reading of this affidavit is the following. 4 days after this homicide, police identify a suspect, Mr. I might be pronouncing this wrong, but Jean Bosco or Jean Bosco. So police identify him 4 days after the homicide. They also are aware, and we'll get to this later, that he uses a nickname Mo. So that's 4 days after the homicide. 1 month later, this defendant, Mr. Robinson, comes forward and says he has information about this homicide, including that he believes 2 people were involved, one of them named Mo. And then this defendant takes his cell phone, shows police a photograph of a firearm sent to him by Mo, a firearm that which was stated in the affidavit was consistent with the firearm seized from Mr. Jean Bosco's car when he was arrested in Quincy, a 9mm Glock, which is also consistent with the type of handgun that was used in this homicide. 5 9mm shell casings were found at the scene. So the main issue here is, the question here is, was there a sufficient nexus established between the crimes that occurred, the homicide, and the defendant's phone? And I think that nexus was established partly by the defendant himself coming forward, saying that he was aware that someone named Mo was involved in the crime, but also showing police that he had potential evidence of that crime within his cell phone.
Do the defendant's statements have to satisfy Aguilar Spinelli? And I'm not suggesting that they didn't with respect to his veracity, because he's named and, you know, he's in custody and they know who he is. But with respect to his basis of knowledge, I mean, he's repeating things that, for all we know, could be rumors. He doesn't give any indication of personal knowledge or observation of any of the events, such as that Mo may have been involved in the homicide, or that the victim and Law were in competition for street level drug sales. What evidence is there that the defendant had any actual knowledge of this?
Well, I'll answer that question by stating there were a lot of links between this defendant's cell phone and the crime. And I think the judge was in error when she said there were only 2 links to the crime. So first, I don't think that, if you're asking about the defendant's statements, I don't believe that it has to satisfy the Aguilar Spinelli standard. I believe that has to do with confidential informants providing information to police officers. So the judge was in error when she said there were only 2 links between the defendant's cell phone and the homicide. She says those 2 links were the defendant's unanswered call to the victim and the photograph of the firearm in the phone. There were more than just 2 links involving the cell phone. I
want to press you on that a little, ADA Bodwin, because as I read your brief, I was looking at pages 11 and 12, which I think is where you lay out what you say are the additional links in addition to those 2. And there was a lot of language there about what the police knew at the time, but I didn't read any of those additional pieces of evidence that had been articulated in the affidavit to link the phone to the crime. In other words, to provide a nexus other than those 2 things that had been identified by the judge in the decision suppressing the search. So it would be very helpful if you could just make the tie for me, instead of talking about how the affidavit is considered as a whole, which I don't disagree with you on that. But what in the affidavit, other than those 2 things, by which I mean the missed call, the missed FaceTime audio call, and the picture of the gun, ties this phone to the crime?
We also know, Your Honor, that this phone was used to call the victim a few hours before the homicide took place. We know from the affidavit that the police, when viewing the
How do we know that?
there is information in the affidavit that the victim placed a cell phone, sorry, the defendant placed a cell phone call to the victim around 5 or 6 p.m. that day. The shooting occurred around 9 p.m. that day. So there is, a few hours in between, but that is another link. And
but that, can I just pause you for 1 minute, just because of the chronology of it? I don't, the earlier call, if I remember the evidence correctly, the earlier call was to set up a drug deal between the defendant and the victim, right? And I think there's it seems like that deal happened and was happily concluded on both sides. In what way does that evidence tie to the later murder of the victim?
My argument is that all these links taken together are that the judge should consider all of these links when deciding whether there's a nexus. I would agree with you, Your Honor, that if all there was this one phone call 3 or 4 hours before the homicide took place, and that's all the Commonwealth had, then I wouldn't be, before Your Honors today. So understanding that by itself isn't enough. But what I was about to talk about was the fact that there were, when police viewed the phone, they saw there was frequent communication between an individual named Mo and the defendant. It didn't say specifically when that communication was, but that is, again, more linkage between the defendant's cell phone and participants in this crime. I think.
Did the police, can I interrupt you? You said the police observed that. I'm looking at the trooper's affidavit, record appendix 59 at the bottom of the page, there's a statement, Robinson also has frequent cell phone-based communications with Mo. Is that, and it's not clear whether that reflects a statement by the defendant or an observation of the trooper. I mean, we don't know, was the trooper allowed to look through Robinson's call log? Where does that come from?
You're correct, Your Honor, that it doesn't specifically say how this trooper obtained that information, whether it was from the whether it was a statement or whether looking at the phone. So I can't definitively tell you. Maybe I misspoke when I said when viewing the phone. There's nothing that specifically says.
But even assuming that the Robinson is in frequent touch with Mo, whoever that is, do we have reliable information in this affidavit that Mo is involved in the crime? I mean, all we have is the defendant's say so, which it does not seem to have any support in personal knowledge, at least none that's stated.
We know that, and I was just, in terms of, before I answer that question, the other links that this defendant has to this homicide is the fact that he was seen interacting with the main suspect 45 minutes after the homicide occurred. And when confronted with that surveillance footage, Mr. Robinson, the defendant here, did not, basically said that was a different person than who the person the police already knew it was, Mr. Jean Bosco.
Well, we don't know how the defendant knows, whether Jean Bosco is an alias and Jones is the real name or what. But how does the fact that the defendant was interacting with this individual with the white stripe on his pants at the gas station suggest that there's evidence in the phone that ties that there's evidence in the phone of the crime?
I think
but it relates to the crime.
Yes, Your Honor. I think the other evidence I just stated deals with the linkage between the phone itself and the crime. This other information is linking the defendant to the crime and its suspects, not necessarily just the phone. So the other information, just the phone, but this is information that also ties Mr. Robinson to the event and the individuals involved in the homicide. And
Attorney Bedoin, I'm sorry to interrupt you, but back to Judge Hershfang's question and Judge Sachs's question, other than making it look like there's a fishy situation involving the defendant and the one photograph of the gun that is consistent with the gun that's used several weeks later, what about those communications is more than, even viewed in its totality, a suggestion that there's something fishy going on, not necessarily that there's something tied to this crime that's going on involving the phone? Where's that information?
That information comes from the defendant when he says, I have information about this crime. I believe a person named Mo was involved with this crime, and police know that the main suspect in the case has a nickname of Mo.
Well, where is that? Does the trooper have a basis of knowledge for that assertion?
No, he does not. And he doesn't state, he doesn't state that what the basis of knowledge was. I'm not sure he necessarily has to state how he knows that. And I think the case is.
Well, I think he does, ADA Bodwin. I think, you make an argument that on page 15, the affiant is a named state police trooper who swore under the penalties of perjury to the accuracy of the information he provided. Fair enough. But the information he provided is only as good as its source. I take it that the Commonwealth is not here arguing that the trooper himself actually was aware, based on his work in this area or his knowledge of local drug dealers or so on, that Jean Bosco was known as Mo, right?
I can't say that because the affidavit doesn't say that. No.
Exactly. And so I think that's the challenge for the judge who reviewed this initially, and for us, is that when there's no basis in the affidavit, it's not enough, I don't think, just to say it was a trooper, because troopers are often given information by, confidential informants or people facing charges or just people looking to mess with them that turns out not to be true. And so that's why the indicia of reliability has to flow through the affidavit to allow the reviewing judge to make a reasoned determination about the reliability of the information that's being provided.
Well, I appreciate that, Your Honor. I believe that a lot of the cases, that the cases that were cited to by the defendant involved, again, confidential informants. And I believe the two of them were, I don't have the names in front of me here, Causey and Penta, which I believe were cases from the late 60s, where the court said that that the affidavit did not talk about the veracity or the basis of knowledge of the information. But I would point out in those two cases, in Causey, the court had a problem with basically all the assertions made in that particular affidavit. There was a quote there that said, "This affidavit is a little more than a disconnected recital of incomplete conclusions." In this case, we're just dealing with one assertion by the trooper. In the other case cited by the defendant, Penta, the issue there was no basis of knowledge provided about where stolen goods were located, which is here. We know the location of the relevant evidence. It's in the defendant's phone, and we know that because the defendant showed police that phone. So I think one assertion by the trooper that he's aware of Mr. Mugisha Jean Bosco's nickname being Mo, I don't think anything further needed to be said by the trooper, especially considering all the other evidence. Now, let's put aside.
May I ask a question about the gun, since we're running out of time?
Yeah.
So we can let's assume, for purposes of argument, that there's probable cause that one of the weapons recovered in Quincy was one of the murder weapons. Is it enough to say in the affidavit that the Glock, the picture of which the defendant showed the trooper, is consistent in appearance? I mean, is it fair to say a lot of Glocks look alike, or a lot of black semi-automatics look alike? Should more than that be required?
I don't think the Commonwealth is required to show anything that firearm is, quote, that picture is definitive proof that was the firearm used in the homicide.
No, but does there need to be something more than it is consistent in appearance? I mean, consistent with covers an awful lot of ground, and we don't know how long the trooper was allowed to look at that photo on the defendant's phone, or what exactly the trooper knew about the firearm that was recovered in Quincy.
I think it's sufficient for the trooper to have said it's probable that this is a weapon used in the murder. They don't need definitive proof. I think they can use. I think a nexus can be established based on reasonable inferences, which is what we have in this search warrant affidavit.
Okay. All right. Thank you. We'll hear from Attorney Daniels.
Thank you, Your Honor. Good morning, all, and may it please the court. My name is Josh Daniels, and I represent Mr. Robinson, the appellee. We are asking you to affirm Judge Kenton Walker's suppression order. I think that the Commonwealth's nexus argument has three key problems here, which will outline the themes of what I want to cover. The first is that standing on their own, the contacts between the victim and one of the alleged shooters and Mr. Robinson on the day of the shooting are not enough under Morin and Fulgium. I don't read the Commonwealth's brief to really dispute that point. What they say, turning to the second problem, it is that Morin and Fulgium are not this case, that this case is out of Morin and Fulgium because of the theory that Mo is really Mugisha John Bosco and that they are the same person. But there's no support for that theory. And so there's also no support for the theory that any Mo related material on the phone relates to this crime. And then the third sort of overarching problem is, as Judge Kenton Walker observed, the affidavit really contains nothing else suggesting that Mr. Robinson's phone was relevant in any way to this shooting, either the planning of it, the carrying it out, the concealment of it. I'd like to take those in turn. So starting with the first point, Moore and Fulgium both teach us that mere telephonic contact with someone connected to a criminal investigation, whether a suspect or a victim, or as in Fulgium, both, on its own isn't enough to create the nexus to the individual's phone. And here, really what the affidavit tells us by way of telephonic contact is, one, Mr. Robinson bought drugs from Mr. Wilson in a different part of Fitchburg 3 or 4 hours before the shooting. Disagreeing somewhat with my friend on the other side, I don't think it's clear from the affidavit that that drug deal was arranged using the phone, but even granting that, the other contacts are that Mr. Robinson left a message that went unanswered at some point later in the day. We don't know when. And finally, that Mr. Robinson had some unspecified, undescribed interaction with one of the alleged shooters, Mr. Jean Bosco, at the gas station soon after the shooting occurred. We don't really know anything about that interaction, and so it's hard to draw much from that, I suggest. But in any event, I think that those contacts alone under Moore and Fulgium wouldn't be enough. I don't really, again, read the Commonwealth to say otherwise. Really what they say is that those cases are distinguishable on the theory that Mo is Mr. John Bosco. Stepping back for a bit, I think it's somewhat obvious, but they're stating outright that in order for the communications with Mo and Law to be related, evidence related to the crime, there first need to be a substantial basis that Mo and Law, whoever they are, actually were involved in the crime. Otherwise, nothing that they talked about could possibly be related if they're just two other people who have no connection to this shooting. The Commonwealth tries to suggest that essentially Mr. Robinson conceded or admitted that he had evidence of the crime on his phone. But I think reading his statements in full and reading the affidavit in full, that's just not what we have here. Really what we have is he said that he suspected these two guys may have been involved, his words, because why does he suspect them? Because they robbed drug dealers, and he knows they have guns, and he knows that they have guns because they've shared photos of the guns with him on social media. And
is the defendant's, are his assertions about Mo and Law subject to scrutiny under Aguilar Spinelli? And he's a named informant. He's not a confidential informant, but must there still be a basis of knowledge shown? Even assuming veracity, must there still be a basis of knowledge before the judge can credit those or can give weight to those when determining probable cause?
It's an interesting question. I'm not aware of a case directly on point that answers it, but if we look at the purpose of Aguilar Spinelli, I think it makes sense that there must be at least some basis of knowledge within the affidavit, even for the defendant's statement, because the whole point of Aguilar Spinelli is to assure that the information relied on by the magistrate or the judge issuing the warrant is sufficiently reliable to give you a substantial basis. And I also think it's worth taking another step back and seeing the broader context, which is
let me just stop you there. If there's no basis of knowledge, could police corroboration of some of the details that he gave that weren't necessarily public details substitute for that?
Of course, since police corroboration can make up for either basis of knowledge or veracity under Aguilar Spinelli. But I think it's worth taking a step back that the line between who is a witness that police talk to and who is a defendant is often very blurry ex ante. And I don't think I think it's potentially dangerous to create a special exemption for at least the basis of knowledge prong of Aguilar Spinelli for someone who happens to wind up as a defendant, since in many other cases that person may just end up being a witness or an informant. I don't know if that answers your question. So moving on, there really isn't an admission that that what is on his phone is in fact evidence related to the shooting. It's just his suspicion that these two individuals, whoever they are, were involved. There's really no basis for that. And the Commonwealth really just tries to get around. The key to the Commonwealth's theory of this case, I think, is the theory that Mo is in fact John Bosco, that they are the same person. And really, there are only two things in the affidavit that they can point to for that. Number one is the nickname. And as we've discussed and as has been briefed, there's really no basis in the affidavit for we just don't know where that information comes from. We do not know how the affiant came to know what he claims to know about Mo being John Bosco's nickname. And without knowing that, we really don't have any way of knowing whether it's reliable enough information to found the probable cause determination. I think even if you were to, I don't think you can get there by reasonable inference, because I think Mugisha itself is such an uncommon name that it's just not reasonable to infer that Mo is a nickname for Mugisha in the same way that Dave is a nickname for David. But even if you could get there by reasonable inference, what I would suggest is Mo itself is such a common nickname that there's a real sort of base rate neglect problem here, in that you'd still have no real assurance that the Mo that you're talking about is in fact the same Mo, even if Mugisha also goes by Mo, if that makes sense. And I think that sort of base rate problem also shows up in the other fact that the Commonwealth points to here, which is the resemblance of the gun in the photo to the presumed murder weapon. I think without knowing sort of how many guns like this one are out there, there's a real danger of focusing too much on the similarity without accounting for how sort of naturally prevalent that similarity is in the world as a background matter. Literally all that we know about this gun in the photo is that it's a Glock handgun. If anything distinguished it, like if it had a distinctive appearance or if it was an uncommon model of Glock, I'm pretty sure the affidavit would have told us that. But it doesn't mention anything about that. So without that, I don't think the fact that the gun in the photo resembles the one found in Quincy really adds much, because presumably, as Justice Sachs, I think you were alluding to, you know, many guns look alike and they are mass produced. And the fact that, you know, this gun, that the gun in Quincy looks just that hundreds or thousands or perhaps even thousands of other guns out there on the street look just like the one in Quincy. The same could be said about the gun in the photo from Snapchat. They can't all be the murder weapon, right? There are at most two murder weapons because there are two shooters. I don't think that really gets us very far. And then finally, on the third point, there's really nothing else here that really implicates Mr. Robinson, or especially his phone, because that's really the focus of the analysis in the line of cases since White in this shooting. Again, under White and the cases that have followed it, even probable cause to believe some involvement by the individual who owns or uses the phone isn't enough to get you into the phone. And really, the affidavit doesn't show anything.
Let's say there's probable cause to think that Mo is involved. Let's say that the defendant had some basis of knowledge that was sufficient to give weight to his assertions about Mo. And we also have some kind of statement in the affidavit, and it may be a reasonable inference that it was a statement by Robinson, that he had frequent cell phone based communications with Mo. Is the fact that the defendant was in frequent cell phone communication with someone who may have been one of the shooters enough to get into the defendant's phone?
Just to clarify, in this hypothetical, do we also have the photo of the gun that looks like the murder weapon, or
Yes.
or is all that we're talking? So
Yes.
I think if we assume that if we take as a given that Mo is that there's a substantial basis to think that Mo is involved in the shooting, and we have frequent contact and the photo of a gun that looks like the murder weapon, I think I probably lose. That's a pretty hard case, I think, mostly because it sort of assumes assumes the things that I need to go my way going against me.
But the only thing different in this hypo is whether there's a basis of knowledge for the defendant's assertions about Mo, isn't there? I mean, isn't that was the only difference between the facts here and the hypo that I meant to inject.
Right, and I think just want to be sure that I'm not over conceding.
Yeah.
So there's a basis of knowledge for if there's a substantial basis to believe that Mo is actually part of this plot, then I think, and there's also a substantial basis to believe that the communications with Mo will lead to apprehension of the suspects or the discovery of other evidence related to the crime, then I think, yes, there's probable cause.
Is the fact that the defendant is in frequent cell phone communication with Mo enough to establish that factor that you just mentioned?
I don't think I think without the picture of the gun and the and the sort of the combination of, we know we're talking with one of the shooters, and we know that a photo of a gun that could be the murder weapon. Without the combination of those two facts, I think if all you had was he's in frequent contact with one of the known shooters, then I think this case is really no different from Warrant or Fulgium. That's sort of what I'm quibbling about there. If that helps, Your Honor, or answers your question. So as I was saying, the affidavit doesn't really show that Mr. Robinson or his phone had any role in the shooting. There's nothing from which you can reasonably infer that he was part of the group that carried out the crime, that he was part of the group that rented the car. There's no motive on his part for having been in on this plot ever suggested in the affidavit. Really what you have are, I think as Justice Hand put it, sort of a fishy situation arising from discrepancies in his statements, which could be a product of the fact that he's being asked about a particular evening a month and a half after it happened. And this, again, totally undescribed interaction at the gas station that at most, I think, suggests that he may know who's responsible, but that I don't think is necessarily coterminous with suggesting his involvement. But those are still not the kind of specific links to his phone that the SJC has said in case after case are necessary to get police into the phone. So in my remaining 40 seconds, Judge Ken Walker, we think, got this case exactly right. She issued a well-reasoned decision explaining why she ruled as she did, and this court should affirm that decision. And with that, I will rest on my brief and thank you for your time if there are no further questions.
Seeing none, thank you both for your arguments.
Thank you.
Thank you.
All right, we are live and on the record.
The next case today is number 21P460, David DeQuattro versus Adler, Pollock, and SHEEHAN. And I think Mr. Entner, we're looking to you first.
Yes, Your Honor. May it please the court. My name is John Entner. I am representing the appellant, which is Robinson Green Beretta Corp. For the purposes of clarifying the record a little bit here, this was a case brought by David DeQuattro and Robinson Green Beretta. However, the only party taking an appeal is Robinson Green Beretta as to the claims against APS and Sally Dowling. Would the court like a brief recitation of the facts of this case?
I think we've got the facts. Just jump right into your argument. If we need clarification along the way, we'll ask.
Very good, Your Honor. Thank you. This is a case about a lawyer who failed to tell her client, Robinson Green Beretta Corp, or RGB, that a shareholder did not intend to fulfill his contractual obligations. This case is coming.
Could I ask you one question that is actually a factual question? Were there additional shareholders other than Beretta, DeQuattro, and Hatcher at the relevant times?
At the time of the 2009 agreement, all the way through the 2016 consent and agreement, the only shareholders were David DeQuattro, Joseph Beretta, and Jeff Hatcher.
And so necessarily the executive committee was made up of some combination of those three throughout that entire time period as well, correct?
That's correct.
And the executive, am I right that the executive committee acted for the company and was essentially the brain of the company? Is that a fair characterization?
Yes, Your Honor.
Okay, thank you.
So if I may just pick up with the one question too many that Justice Hand didn't ask in her questioning. You argue on pages 11 and 12 of your brief, if my notes are right, which they may not be, that counsel failed to inform what you call in your brief RGB as an entity, that the firm had the right to buy out Beretta. And I want to understand what Attorney Dowling, I don't know how you pronounce that, should have done in your view. Because Beretta knew, DeQuattro knew, Hatcher knew. Is there someone else that should have been told? And if so, how?
Well, the allegations in the complaint are that DeQuattro and Hatcher did not know the terms of the 2009 agreement. And actually, on admission, the defendants also did not know the terms of the 2009 agreement until Mr. Beretta contacted Attorney Dowling. Attorney Dowling then spent an hour of her time reviewing the 2009 agreement, was reminded that Beretta had an obligation to sell his shares to RGB, and informed Beretta of that obligation. But importantly, she never informed RGB either through DeQuattro or through Hatcher. And
but
in
both,
that,
sorry, I want to make sure we're getting the facts. I'm getting the facts timing right. I trust that hours of review and informing Beretta you're talking about is all before both Hatcher and DeQuattro signed their respective agreements. And I think April and June, if I have the dates right, of 2019, saying notwithstanding the provisions of the 2009 agreement, they were going along with the sale of shares. Do I have that timing right?
You do, Your Honor. In spring of 2015 is when Beretta contacted APS and Dowling regarding the 2009 agreement. So a year before the consents were signed in 2016, and a year before the 2016 agreement, Dowling and Beretta both knew the terms of the 2009 agreement, having reminded themselves essentially with the assistance of counsel. Now that's important because at the moment that Beretta advised Dowling that he didn't want to sell his shares back to RGB and didn't want to lose control of the company, his interests diverged from RGB's interests. And at that time, APS and Dowling are corporate counsel. They have a duty under the rules of professional conduct, rule 1.13, section B. When an attorney for a corporation or an organization knows that a shareholder or an officer or somebody associated with that organization intends to not fulfill an obligation to the organization, they have a duty to inform the organization.
Okay, but what harm could have come from that if at the time the written consents were signed by Hatcher and DeQuattro, both of those consents said notwithstanding the 2009 agreement. So even if they didn't know at the moment that Beretta came to Dowling, they clearly knew before they signed those consents because they are presumed to have read them before they signed them. So if they said, oh, what's this 2009 agreement that we're giving up rights under? Isn't that on them rather than on Dowling for having failed to inform them at some prior time?
Regardless of the presumption that DeQuattro and Hatcher knew the terms of the 2009 agreement, it doesn't alleviate Dowling from her 1 year prior, in 2015, from her obligation to inform the corporation. She can't rely on a presumption that arises a year later that they knew the terms of this agreement when she knows that Beretta had forgotten the terms and when she herself had forgotten the terms. And also,
just though, Attorney, before just on that point, and I'm sorry to interrupt you, why isn't Adler Pollock correct when it says that Dowling heard the preference that Beretta had that he didn't want to give up majority control, informed him that he had already done so. It was too late for that. And then there was no further word from Beretta at that point about wanting to or planning to in some way subvert the earlier 2009 agreement. Why didn't Attorney Dowling fulfill her obligations by having told Beretta he had already given up that right? And why was she then obligated to report to the company that conversation?
This is a motion to dismiss, and on a 12b6, the court is required to view the facts alleged in the complaint in the light most favorable to the non-moving party. Our amended complaint alleges that he announced to her that he did not want to cede control of the company to RGB, which is akin to announcing that he has no intention of fulfilling his obligation to sell the shares. Furthermore, in additional paragraphs in our complaint, we allege that multiple conversations took place. That first one was memorialized by an email. There was another one further memorialized by another email that took place later in 2015. And then again, another conversation in June of 2015. The court's required to take those allegations in the light most favorable to us. Those are specific dates and specific.
What is alleged about those conversations in the complaint that plausibly suggests she breached her duty to RGB?
Well, the allegations are that Beretta continued to seek Attorney Dowling for ways he could get around the 2009 agreement or get around his obligation to fulfill the 2009 agreement by selling the shares to RGB. He wanted to know if he could get more controlling interest in RGB. He wanted to know if there was some way he could get out of his obligation to RGB. And he's signaling that he's looking for individual representation, individual legal advice for how he can, in a position that is adversarial to RGB, gain an advantage. She owes a duty to RGB at that moment.
The only evidence, and I guess I shouldn't use the word evidence, the only allegation we have in the complaint about the interaction, about the substance of the interaction between Mr. Beretta and Attorney Dowling at that point in time, which is to say before the later deals were entered into, is that he came to her and said, hey, I don't want to give up control. And she said, so sorry, too bad, too late. You did that already. How is she not representing RGB and RGB's interests when she says that to him?
She is representing RGB's interests to the extent that she advises him, you have already given up control. But what she doesn't do is advise RGB. She doesn't tell anybody at RGB, hey, Joseph Beretta is seeking to get around, to get out from under this obligation. He contacted me and asked me what his obligation was. And I saying he didn't want to do this. And I told him he has to. She owes a duty to speak, to inform RGB of what's going on and not just simply hold on to that information, particularly when Beretta continues.
I'm sorry, I just want to make sure I'm following the facts. Wasn't Mr. Beretta the majority shareholder of RGB at the time that he had that conversation with her?
He was the majority shareholder of RGB at that time, yes.
Okay.
Which is why.
And so isn't his knowledge imputed to the company at that point?
I don't think you can impute Beretta's knowledge to the company because of Baker. He's a majority shareholder, yes, but he's announced an intention to not fulfill an obligation he owes to this corporation that has minority shareholders. The corporate counsel owes it to the minority shareholders under the relevant rules of professional conduct and under the case law in Baker to inform the rest of the company that a majority shareholder is seeking to evade his obligations to the corporation.
Isn't that different from saying that RGB was not informed, though? I mean, I think I hear your argument, but I started my questioning asking what it was that counsel should have done to inform the company. I'm not sure we've gotten to an answer to that yet.
The simplest thing, Your Honor, she could have CC'd Jeff DeQuattro or Jeff Hatcher and David DeQuattro on that email saying the 2009 agreement requires that Beretta sells his shares to RGB on his 61st birthday in 2016.
Well, I'm sure, in retrospect, I'm sure she wishes she had, right? But that's different from saying that it was a violation of applicable laws and professional rules of conduct not to have done
she's under a duty to inform the minority shareholders in the company when a shareholder of any size intends to not fulfill an obligation. Rule 1.13b states, let's see here. If a lawyer for an organization knows that an officer or other person associated with the organization intends to act or refuses to act in a manner related to the representation that is a violation of a legal obligation to the organization, and that is likely to result in injury to the organization, then the lawyer shall proceed as reasonably necessary in the best interests of the organization. And here she never informed anybody that the 2009 agreement required that Beretta was going to sell his shares and that he was trying to get around that obligation. Now, I'm running a little bit low on time, and I did want to address quickly the court's reliance on Hull and my brother counsel's reliance on Hull as the controlling precedent in this case for the idea that they are presumed to have known. First of all, in Hull, that's a presumption. It's not a fact, but it should be rebuttable. And I think that the controlling case here should instead be a subsequent case that this court decided in 2014 called Genovese v. And I apologize, it is Genovese v. Nelson. The docket number for that is 85 Mass App Court 43. In Genovese, the plaintiff pled sufficient facts to allege a violation of a fiduciary duty, and the trial court presumed that the plaintiff knew the contents of the document. The appellate court decided that the presumption was wrongly applied for three primary reasons. First, Genovese had pled that he never had a chance to review the document, and so therefore the knowledge of its contents couldn't be imputed to him. Second, Genovese alleged a breach of a fiduciary duty, which had not been the case with Hull or with any of the subsequent cases that cite Hull. And third, the presumption had never been applied at a motion to dismiss level. The presumption is a rebuttable presumption that has been overcome, I think, for the purposes of a motion to dismiss, where it alleges sufficient facts to get us into discovery. Like Genovese here.
By the time that the written consents were filed, I mean, is there any reason to question the presumption that when DEQUATTRO and Hatcher signed the written consents, which said, notwithstanding the 2009 agreement, that they weren't aware of that? I mean, they might have forgotten about the 2009 agreement sometime between 2009 and 2016, but then they're reminded again.
Well, they aren't reminded. That's the problem. The only person who's they're aware of its existence, but they're not aware of its terms. And that's not a speculative allegation. That's an allegation that's rooted in the admissions of the defense. Attorney or Beretta forgot the terms of the 2009 agreement, and he had signed it. Dowling herself, an attorney who represented parties in the drafting and signing of the 2009 agreement, had forgotten what it was. If this court allows a trial court's order to stand, essentially what it will be letting happen is majority shareholders can use corporate counsel to push out minority shareholders. You're stacking the deck in favor of a majority shareholder by presuming that if the majority shareholder knows, then the corporation knows. And if
you say that they can use corporate counsel to push out minority shareholders, as of the time of the filing of the complaint, how had RGB, as distinct from DEQUATTRO perhaps, been injured by counsel's conduct?
RGB was damaged because Beretta was scheduled to no longer be an employee of the company as of his 65th birthday in 2016. Instead, without the knowledge that that was a requirement, it entered into another agreement that extended his employment for a large amount of compensation all the way through 2019. That's 3 years of salary that they wouldn't have had to pay to this large shareholder and employee. I'm running low on time, so I would like to reserve my last 15 seconds for a quick rebuttal, although I think it may be futile at this point.
We don't have rebuttal, so give it your best shot in summing up or making any last point.
Your Honor, I think for all these reasons that this court should remand this case to the trial court for responsive pleadings and further discovery.
Thank you.
Thank you.
Mr. Reisberg.
Thank you. May it please the court, Mike Reisberg for the appellees and defendants, Attorney Sally Dowling and Adler, Pollock and Sheehan. Maybe I'll just pick up on where the court was focusing in my brother's argument. There seemed to be a lot of interest in the conversation that is referred to in the complaint on March 15 of 2000, March 16 of 2015, when Mr. Beretta called Attorney Dowling to let her know that he didn't want to relinquish control of the company. And then she emailed him that day. That email is Exhibit 2A to the first amended complaint. And she told him, too late. She sent him a copy of the 2009 agreement and told him, you already have relinquished control. You've already agreed to sell your shares on your 65th birthday. Now, my brother makes a lot of this conversation and says that there was a duty on the part of Attorney Dowling and Adler, Pollock, and Sheehan to disclose this to the minority shareholders because it put her on notice of Mr. Beretta's intent to freeze out the minority shareholders and not abide by the 2009 agreement. I think you got to focus on what Mr. Beretta said to Attorney Dowling in that conversation. He said he didn't want to relinquish control. And she told him, it's too late, you have to. And you have to go ahead and sell your shares. This case isn't about his refusal to relinquish control. It's not about his refusal to sell his shares. So there's nothing that he told her in that conversation that has any relevance to the breach of fiduciary duty and the breach of the 2009 agreement that they allege in this case. And they allege that breach is the result of the failure to disclose the 2009 agreement to them and the failure to remind them of his obligation to sell his shares back to RGB on his 65th birthday. There's no evidence that he was ever unwilling to relinquish control after he had that conversation with Attorney Dowling or to sell his shares. In fact, the case is about the manner in which he went ahead and did that. And so my brother suggested that what Attorney Dowling should have done at that point was emailed or copied the minority shareholders on that email. So if she had copied them on that email, they would have just seen that he was being told, he was asking, I want to relinquish control, and she's telling him you can't, and she's reminding him of the 2009 agreement. That wouldn't be telling them anything more than what she made sure they knew in the spring of 2016, when she prepared the written consents that they specifically signed, acknowledging that the transfer of Mr. Beretta's shares in the spring of 2016 was done with their consent, and it was done notwithstanding the terms and conditions of the 2009 agreement. I mean, the predicate allegation of these claims against Adler, Pollock, and Sheehan and Mr. Beretta is that RGB and Mr. DEQUATTRO were defrauded because they were not informed of the 2009 agreement or reminded of the 2009 agreement. It's not that Mr. Beretta was unwilling to give up control, something he said a year earlier, and never expressed any further willingness to give up control, and never demonstrated any further act to not give up control. In fact, he went ahead and gave up control. He went ahead and sold his shares. So it really is hard to see what more information RGB and Mr. DEQUATTRO needed, other than Mr. DEQUATTRO expressly acknowledging and waiving the 2009 agreement. So I think the trial court properly found here that under the Ianchino standard, which I think was critical in the background of the court's rule, that's the proper standard for reviewing a motion to dismiss. And Ianchino instructs that it's, mere labels and conclusory statements in a complaint are not sufficient to state an actionable claim unless they find plausible support in the facts actually alleged in the case. And the facts alleged in this complaint not only don't support the conclusory assertion of a failure to disclose the 2009 agreement to Mr. DEQUATTRO, they refute that core allegation because they demonstrate without any doubt that Mr. DEQUATTRO was reminded of the 2009 agreement, and he signed a document waiving the agreement. And I don't think it's controversial to say that it's well established in the Massachusetts law that a signatory is presumed to know the contents of a document that they signed.
Is there an allegation in the complaint, and I should have asked appellant's counsel this, that that Hatcher and DEQUATTRO were not aware of the provisions of the 2009 agreement at the time they signed the written consents?
I mean, it can be inferred. The conclusory allegation is being made that there was a breach on the part of Beretta, and that Adler, Pollock, and Sheehan and Dowling assisted him in that breach by somehow concealing from them the 2009 agreement and its requirement that RGB purchase Mr. Beretta's shares on his 65th birthday. But that is the very type of conclusory allegation that has to be plausibly supported by the factual allegations in the complaint. And the trial court judge here very much correctly concluded that when you consider these operative documents, the written consents that Mr. DEQUATTRO signed in April of 2016 and again in July of 2016 demonstrate without dispute that he was aware of the 2009 agreement, and he was reminded of the 2009 agreement a little over a month before RGB's buyback date under the 2009 agreement, extinguishing any doubt that he could possibly have been unaware of it. And it's really...
I do see an allegation, paragraph 42 of the First Amendment complaint, that as of March 31st, 2016, the executive committee approved the sale of Hatcher's shares of stock because Mr. DEQUATTRO and Mr. Hatcher were unaware of the requirements of the 2009 agreement. Does that have to be taken as true on a motion to dismiss?
I don't know how that can be taken as true here when it is directly contradicted by a document that's part of the operative pleadings here, and no one's disputed that the Hatcher consent and the Beretta consent were properly considered as part of the operative pleadings here. They're signed documents by Mr. DEQUATTRO in which he is expressly consenting to the fact that this transfer is being made notwithstanding the terms and conditions of the 2009 agreement. We also have the 2009 agreement itself, which he signed. But I think that the trial court properly found, even if you could argue, even if there's a suggestion that he forgot about it, he was reminded of it at least a month before the RGB's buyback date under the 2009 agreement.
But I think, Attorney Reisberg, I may have the chronology wrong here, but I think that the allegation that Justice Sachs just read comes a month earlier or in the month before the Hatcher consent was signed, right? So if I'm right about that, I think it could be that the court was required to take that allegation that Justice Sachs just read as true, but then subsequent to that point in time, there is the signed consent, which shows, notwithstanding the provisions and so on.
Okay,
Is
so
that right?
even if there could be an inference that Mr. DEQUATTRO doesn't know in March of 2007, or he's forgotten because he signed the agreement in 2009. So he is presumed to have known it. But as the trial court found, to the extent that the complaint can be read to suggest that he forgot it by March of 2016, well, he's unequivocally reminded of it by April 1 of 2016 when he signs it. So it's really very difficult to imagine what else Attorney Dowling should have done as corporate counsel for Adler, Pollock, and Sheehan. Let's focus on the allegation, which they also have to prove, which is that she assisted somehow in defrauding RGB and Mr. DEQUATTRO, which is also the same basis of the allegation that they breached a standard of care necessary to support the legal malpractice claim by not disclosing this. What more was Attorney Dowling supposed to do to ensure that this disclosure was made, other than to draft two very specific documents, the material part of which is only a sentence? It's a single sentence in each consent, which basically says, we're signing this as all the undersigned, as all the shareholders of all the outstanding stock of RGB. And we acknowledge and we consent to this transfer, notwithstanding the terms and conditions of the January 9, 2009 agreement. I don't see what more Attorney Dowling could have possibly done. Importantly here, the real crux of the claim of malfeasance on the part of Mr. Beretta and what supposedly causes harm to Mr. DeQuattro and somehow to RGB is that as a result of selling his shares to Mr. DeQuattro directly rather than RGB, they're sold to Mr. DeQuattro at a higher price than would have been paid by RGB, okay? But there's no allegation that as corporate counsel, Attorney Dowling or Adler, Pollock, Sheehan are ever told the price that Mr. DeQuattro was agreeing to pay for the shares, or that Adler, Pollock, and Sheehan or Attorney Dowling would have any way of knowing that that's a higher price than the fair market value of RGB. There's no evidence as to what the fair market value of RGB is, or how corporate counsel could possibly know that, or how corporate counsel would possibly be in a position to second guess the decision of Mr. DeQuattro as to what he wanted to pay for the shares. I mean, that clearly crosses over the line of what Attorney Dowling and Adler, Pollock, and Sheehan are supposed to do as corporate counsel, involving themselves in the business decisions of RGB and Mr. DeQuattro. And I think that does go to the trial court's, one other point. The trial court, I think, also properly found here that there's a very question as to whether there was any underlying breach here at all committed by Mr. Beretta, where you've got all the parties to a contract basically agreeing to vary from the contract and enter into a different agreement. And they all consented to it, and they all decided to do it. And what's improper about that? With respect to, I think the trial court also raised a very good question as to whether there is any harm here that's being alleged by RGB, even if there was a breach. If Mr. DeQuattro in fact paid more for the shares than RGB would have paid for them, and as the trial court properly found, that would have been a harm to Mr. DeQuattro, not to RGB. Mr. DeQuattro is no longer a party to this case. Mr. DeQuattro is not a party to this appeal. And to his credit, when asked what the harm was, my brother didn't even refer to the higher stock price, because that wouldn't be harm to RGB. So instead, the only harm that he offered, which is discussed in their brief, was that, well, this all somehow resulted in Mr. Beretta continuing to work at RGB for another several years beyond when he would have left under the 2009 agreement. Well, that decision to extend his employment, that was a decision that Mr. Beretta and Mr. DeQuattro made under the 2016 agreement. Right? There's no allegation or evidence that Adler, Pollock, and Sheehan or Attorney Dowling played any role in creating the 2016 agreement. And that's what led to Mr. Beretta's continued employment there. And even if the 2009 agreement was completely fulfilled, there would have been nothing to prevent Mr. DeQuattro and Mr. Beretta from entering into another agreement like the 2016 agreement and deciding, for whatever business reason they made the decision, to keep Mr. Beretta there for another several years. There's no way in the world you can connect any harm that results from his continued employment there to any act or omission on the part of Adler, Pollock, and Sheehan or Attorney Dowling. Thank you.
All right, seeing no further questions, the case is submitted. Thank you both for your arguments, and we'll take a short 5. Attorney Tucker, it's up to you, but if you want to be closer to the camera so we can see you better, you're certainly welcome to. You don't need to stand as far as we're concerned.
It's a habit of a lifetime, Judge. I will, I'll tell you what, we'll do it this way. Is that preferable?
It's up to you, really.
Thank you.
Okay, we are live and on the record.
All right, our fourth case for this morning is number 21P676 EMG Realty LLC versus Mark Reed. And I believe we're hearing first from Attorney Tucker for Mr. Reed.
Please, Judge. Good morning, Your Honors, and may it please the court. My name is Michael Tucker, and I practice law in Peabody, Massachusetts, and I represent the appellant, Mr. Reed. We're here this morning because the judge in the trial court and you can find it Appendix 178 of our appendix, the ruling that says in part, since the counterclaims in question, which are not compulsory, are being dismissed on procedural grounds, such dismissal is without prejudice. And then the court goes on to say, the court does rule that the underlying tenancy was terminated for cause, and such ruling may temper the viability of the defendant's counterclaims for violation of the eviction moratorium. Mr. Reed and his mother were tenants at will without lease in 2 units that were owned by EMG.
Just since you started that way, I want to back you up. Does that statement of the judge that since this was for cause, it may temper the viability of the defendant's counterclaims, does that have any binding effect in whatever litigation may occur after this appeal?
I believe it does, Judge, and I believe that the trial court judge believed that that was the case. That becomes the law of the case for the purpose of, there were 2 dockets in the district court, there were 2 subsequent dockets in the housing court. It was consolidated into a single civil docket, and that ruling is found in the civil docket that controls the case going forward and the counterclaim. So that's what
I wanted to ask you about that placement on the civil docket. The judge ruled that the counterclaims couldn't be brought in a summary process action because it was in essence, not a without fault or non-payment of rent action, and therefore had to be brought as affirmative claims in a separate action. But hadn't the claims already been transferred to the civil docket? What was to be accomplished by dismissing them and then having the defendant file them all over again?
Well, nothing that I could tell, Judge, except that the defendant, the defendant in counterclaim, plaintiff in counterclaim, suffers from the effect of having this ruling, which the trial court judge expects to carry over into the subsequently filed complaints. The counterclaim's rights are limited by the virtue of the fact that the court found that this was a for-cause eviction. It's that we dispute.
But let me ask as a procedural matter, what sense does it make to order them, the counterclaims dismissed because they can't be filed in this sort of summary process action when in fact they've already been transferred from the summary process docket to the civil docket?
I don't think it makes very much sense at all, Judge. I attribute that to the confusion of having 2 district court dockets, 2 housing court dockets, a subsequent consolidation of the docket. Mr. Reed, there was and you'll see in the record, there was a stipulation filed. Mr. Reed and his mother gave up the 2 units to EMG as far as possession was concerned and reserved only the counterclaims for hearing in that civil docket.
So, sorry, go ahead with your argument.
Well, actually, if Justice Sachs is done, sorry, let me just follow up on that one point you just made, Attorney Tucker. So I saw the stipulation. I saw that obviously the ruling that it was for cause. How do those 2 things go together? In other words, does the judge's conclusion, I think you just said that the judge's ruling that the eviction was for cause is the law of the case, and now you're stuck with it and it carries forward. Is there any way or reason for us to look at whether there's actually any foundation for the conclusion that it's for cause, given that the stipulation, if memory serves, reserves on that issue and does not conclusively decide it?
Judge, you're correct. The stipulation does reserve on that issue very specifically. And it was our intent that those counterclaims continue in the civil docket that existed at the time. We didn't dispute possession. In terms of whether it makes sense for you to consider whether it was for cause, my suggestion to you is that it makes all the sense in the world. We're here because the judge ruled as a matter of fact at a Rule 12 motion to dismiss hearing, which this court has the right to review de novo. He held as a fact that the eviction was for cause. There was no basis on which a judge could find that as a fact, and the consequences of having found that as a fact were two. One, it avoided the moratorium that was problematic and in effect at the time. And two, Section 8A allows counterclaims to be treated differently when an eviction is for cause.
Okay, going back to the first point, if I may, you say that in essence, I think you're arguing that it would negate the applicability of the moratorium if it was a for cause.
That's correct.
But I'm not seeing that in the language of the moratorium statute, which says that the, I mean, it says sorry, I'm just trying to get to the language of the statute, that the an eviction is non-essential. Doesn't there have to be criminal activity involved in order to get the eviction done despite the moratorium?
Well, I believe the judge was wrong, but I believe the judge was concluding that the eviction was not in violation of the moratorium. It was in fact for cause. He said as much. And as a result,
well, he said it may temper the viability of the counterclaims. I don't think he ruled that the counterclaims were defective as a matter of law. Or, you know, since there was not even an allegation of criminal activity that would take these evictions outside of the moratorium, even if it was a for cause eviction, I don't see how that negates the claim that it was in violation of the moratorium.
Well, I'd only suggest two things, Judge. One, Mr. Reed was a tenant at will without a lease, and his rent was paid to date. So he had no basis on which to oppose an eviction. We haven't filed anything that indicates that there was a problem with the health inspector in the city of Newburyport or any such counterclaim. The issue that we had and have always had from the outset is that the eviction was brought for cause at a time when you couldn't bring an eviction for cause. And the trial judge's ruling was that this eviction was, as a matter of fact, for cause.
Well, you could bring an eviction for cause if it involved allegations of criminal activity that may impact the health or safety of other residents.
Right, and
that's what the statute says. I don't see an allegation of such criminal activity. So
the judge apparently credited the 258E hearing that was ultimately vacated when it was finally heard other than ex parte.
So
as that basis.
Let me put the question to you this way. But for that sentence in the judge's order dismissing the counterclaims, is there a problem with what he did, or is there a reason why this shouldn't have just been transferred to the, I mean, it was already transferred to the civil docket.
Judge, but for that sentence in the judge's order, we would be in the same civil docket carrying our counterclaims forward as we intended when we signed the stipulation. We have no objection to that. So then just addressing briefly, in terms of the facts, the judge didn't have the it didn't have a basis on which to find that the eviction was for cause, as a matter of fact. Certainly didn't have a basis to carry that finding forward into some future docket that he anticipated being part of the history of the case. And the reliance on the 258E harassment order and the transcript that you find in our appendix at page 231, Judge Doyle in the Newburyport District Court was approached with that 258E when it was finally heard other than ex parte. And the woman who brought the complaint asked that the motion was vacated, 258E order was vacated as soon as there was a hearing. The woman asked, can I please add to, this is line 7 on our page 231, can I please add to the report that we would also like Mark's daughter out of the building. The eviction he originally sent to him was for all of them, not just him. Judge Doyle indicates later in the page that he understands that there's an eviction involved. He also understands that they haven't met the standard for harassment order. He refused the harassment order and sent the eviction back to, at that time, I think the docket was in the Newburyport District Clerk's office. It's our allegation that the use of another resident's 258E harassment order to try to gin up a cause under which an eviction could be brought under the moratorium is a violation of the moratorium. It's a violation of 8A, and it's a violation of 93A, and in our particular case, caused my client some particular emotional distress. We served our discovery, and under the rules of the housing court, that gets filed. The judge had that at his fingertips when he wrote his opinion. That discovery hasn't been answered. We're only at the Rule 12 stage. I believe that we've made a case that is more than plausible under the language of the rule, more than plausible as to our counts and causes of action. To have it dismissed or to have them reinstituted with a shadow over them regarding the finding of fact is an issue that creates for us the problem that puts us here.
Can I ask you about the basis for dismissing the so-called third-party claims? The judge did so because they didn't seek contribution or indemnity. Can those claims be viewed not as third-party claims, but as the Mr. Reed joining Dr. Gasiorowski as a defendant in the counterclaims that he brought against the original plaintiff, EMG? So he's asserting the exact same claims against Dr. Gasiorowski as he did against EMG. Why isn't that a case for joinder of a party under rules 13H and 20A?
20A. Judge, I believe it is. That was our intention at the time. The procedure in the housing court during that period of time was more than convoluted, and we understood from the way the procedure was going that we were about to lose our original counterclaims pursuant to the order of the court. We asked the court to join that complaint to this one for purposes of getting a final order such that we could bring it to your honors. So moving on briefly, Judge, I see that my time is running down. The question about whether the moratorium provides a private right of action as to a tenant against a landlord, I think is one that has been litigated well in the past. We would rely on the Berdos case, and I know that my brother is looking at Lafredo as the primary case that he would rely on to say that Berdos doesn't control. The issue with Lafredo and some of the other cases that are in the appellee's brief, he's got cases that relate to preliminary relief. He's got cases that relate to federal jurisdiction. The Lafredo case is an administrative law case. It has to do with whether there's a private right of action under a CMR that is a regulation promulgated by an agency. This is not the case here. This was an emergency piece of legislation that was enacted by the legislature and signed by the governor during a period of time when there was a pandemic. And the specific concern of the legislature was that tenants would be found without houses in a time when no one was working or able to leave their homes and other housing wouldn't be available.
May I ask you this? Let's assume for the purposes of argument that there's no private right of action directly under the moratorium statute. Could a violation of that statute also be considered a violation of Chapter 93A?
Oh, well, we believe it could, Judge. Certainly there's nothing directly on point, but that would be our argument. It's an unfair and deceptive practice to bring a for-cause eviction in a circumstance in which a for-cause eviction isn't appropriate.
And would you get any different, or, I mean, since the moratorium statute doesn't provide for any particular relief in a private action, but 93A clearly does provide for relief, including treble damages and attorney's fees in appropriate circumstances. I mean, are you any worse off pursuing that claim under 93A?
Only to the extent, Judge, I think that the moratorium relates back to chapters 186 and chapters 239, which specifically provide rights of action to the tenant and treble damages and other remedies available to tenants that have been mistreated by their landlords. I see my time is short. I'll leave the 259H argument. Thank you.
All right. Thank you. And Mr. Mack, we'll hear from you now.
Good morning. I think it's still morning, Your Honors. David Mack for the appellees, EMG Realty and Kevin Gasiorowski. I want to just touch on a couple of the clarifying questions or factual questions and procedural history because I think all the discussion sort of illustrates why it's our request that the court tackle the merits, which is what we had actually requested that the housing court do. First of all,
Well, let me ask whether we can do that, because these dismissals were without prejudice. You didn't cross appeal. If we were to rule that the claims were defective on the merits and order them dismissed with prejudice, that would be granting you greater relief than you obtained in the trial court without you having appealed. Do we have the authority to do that?
I think you do, Your Honor. I think that's well settled that any reason that is supported by the record.
Any reason to affirm the judgment, but the judgment here, if we can call it a judgment, was dismissal without prejudice. You're asking us to go beyond what the trial court did and dismiss with prejudice.
Yeah, my understanding is that that you can reach the merits of the case as long as they're supported on the record. We argued it below, and just because the court didn't take us up on that doesn't mean that this court can't address it. And in fact, it would be, we believe it would be wise to do so, because it would prevent subsequent ongoing litigation and potentially even a second appeal. On the issue of, first of all, on the moratorium, I would point out that there doesn't need to be criminal activity in order to make it exempt from the definition of non-essential eviction. There's a second provision that talks about lease violations. Now, granted, there's no lease, but it clearly provides that if the tenant at will, if you will, engages in activity that may impact the health or safety of other residents, healthcare workers, emergency personnel, persons lawfully on the subject property, or the general public. And that's the provision that we were seeking on. Now,
well, but it doesn't say for tenants at will. It says lease violations. So tenants who signed a lease get certain benefits from that, but they also have certain burdens. They may undertake higher obligations. And it seems like Clause B of the definition of non-essential eviction encompasses that, but how can you extend it to tenants at will?
Well, because I think, Your Honor, I think it would fall into that principle that the court shouldn't interpret legislation to end up in a result that's absurd. And in my opinion, giving more protection to a tenant at will who has no lease, who's committed acts that threaten the safety, and he's threatened to cut people's throats. But just because you don't have a lease, you have more protection than if you had a lease. I don't think that's what the legislature in an emergency session would possibly have intended. So I agree that on the face of the statute, if you read it strictly, that if you don't have a lease, then I guess Clause B on its face wouldn't apply. But I would think, Your Honor, I submit that in this situation, that the legislature couldn't have intended that someone could get away with threatening other people in the building, threatening to cut their throats, threatening to kill their boyfriend, and just that person can't be evicted simply because they didn't have a lease. I don't think that's what the legislature possibly intended.
Well, but
I mean, those
Mack,
might. Sorry, go ahead. No, those could constitute allegations of criminal activity, conceivably. But that wasn't alleged in the notices to quit or the notice of termination of tenancy.
Right. Well, there hadn't been a prosecution yet. There had only been, encounters. And here, I think that
There doesn't have to be a prosecution. It just has to be allegations of criminal activity.
Well, we certainly identified the incidents and altercations that had been repeated, and he was quite aware of it as the police had responded. So, we believe that the eviction, and in any event, it's sort of, it's beside the point in the sense that there's no private right of action under the statute. And I don't think, I think what the court was doing in that statement, to talk about this statement that triggered the appeal, to me, as much as I would have liked the court to have expressly held that there was a for-cause eviction, I think the court that was probably dicta. And the court was indicating, look, the complaint at least alleges activity that would constitute a cause. We never got to that point, of course, because possession was conceded and we entered judgment, and then we just went forward on the counterclaims. And this sort of illustrates the entire point why we should have a discussion on the merits, because it's always been curious to me why Mr. Reed didn't simply just refile everything anew, because it was a dismissal.
That brings up the procedural question.
Right.
The judge says these can't be counterclaims in a summary process action because it was for cause and 8A
Right.
doesn't allow it. But these claims had already been transferred to the civil docket. What was the point of dismissing them?
Well, I think it is advancing form over substance, Your Honor. I do agree with that. But at the time the complaint was brought, the counterclaims and the third party complaint, it was a summary process case. And when we moved to dismiss, it was a summary process case. And so,
but the cases had those claims had already been transferred to the civil docket when the judge said they should be dismissed because they can't be brought in a summary process action.
Right. And so, Your Honor, I think it ends up in the same situation, right? If your honors decide that you can only address the procedural issue, right? And we go back, either if the court reverses it because it was an improper ruling on the procedure, or whether the court affirms the dismissal without prejudice, we end up in the same position, right?
So
we get back to the beginning.
Just to complete that line of reasoning, the dismissal of the third party claims, they might not have been third party claims in the sense that they didn't seek contribution or indemnification, but would they be proper counterclaims against a defendant joined with EMG as the original plaintiff? In other words, the defendant, Mr. Reed here, brings these three counterclaims against EMG. He's got the same claims against EMG's principal, Dr. Gaziarowski.
Right.
Can't he join the doctor as a defendant under the joinder rules 13H and 20A?
If that's what he had done, so let's say we had solved the possession issue before this, these claims for damages arose, or he made these allegations, the proper thing would have been just file a complaint against all defendants at one, direct claim.
But is that a
14
question?
Was designed to deal with claims by the existing defendant against a non-party for contribution and indemnification. But yes, you're correct that
Rule 14 agreed, but what about Rule 13? I mean, he might have made a mistake by labeling his claim a third party claim. But isn't it a proper claim nevertheless, because he's seeking to join Dr. Gaziarowski with EMG as the defendant to the same three identical claims?
Yeah, I can't quarrel with the fact that the plaintiff, counterclaimant, defendant, whatever you want to call him, was bringing direct claims against the EMG Realty and its principal, acting in an agency capacity. So I can't quarrel with that. I just but for the fact that this occurred in the setting that it did and in the procedural history, and that the court addressed the procedure, not the substance, we wouldn't even be having these discussions, because clearly you can bring a claim as long as you have the facts, of course, against someone who's an individual committing an alleged tort on behalf of an entity. That's been settled law for centuries. I can't quarrel with that. So, but turning to the substance, I think the briefing, I'll stand on my brief in terms of the private right of action. But if you look at the actual allegations, and that's really where what I would respectfully submit is where the problem of the complaint is, that there's nothing in the complaint that alleges that anything that Dr. Gaziarowski did, in fairness to him, trying to fulfill his duty to his employees who worked in the building, to other tenants who rented units from him, from guests of other tenants. There's nothing in the allegations in the complaint, the complaint I used collectively to refer to the counterclaim and third party complaint, that said that anything that Dr. Gaziarowski did was improper, in the sense that nothing he said was false, nothing he said was misleading, nothing he and everything that he submitted was to a court in support of someone who was threatened in the very same way that he was personally threatened, and his property man was threatened. This man had been a growing menace to everyone with whom he came into contact with. And the legislature specifically said, smartly, exempted these types of evictions in the residential setting. We didn't have an issue. Of course, he had paid the rent, and we tried, as the record reflects, to work diplomatically with his mother, who had occupied the unit, and we hoped could de-escalate the situation, but it didn't work. And so once the situation escalated even further, where the police had to be called yet again because Mr. Reed had threatened to slit someone's throat, where we felt like Dr. Gazarovski had to do something. He's in a catch-22. If he doesn't try to evict this person, and then Mr. Reed goes off and hurts Miss Thon, who went in for a 2258E order. And by the way, initially he was ordered to leave by the court because of Miss Thon. It's only because she only had one incident of threats to herself. What is Dr. Gazarovski to do here? Sit by and wait for someone to get killed? And now he's sued for damages. And this, again, that's the only thing here. Are the allegations enough to merit a finding, a plausible finding that what he did was extreme and outrageous and not acceptable in society? I think it's the opposite, Your Honors, that he should be applauded for standing up and doing what's right and not submitting, according to Mr. Reed himself, anything false, anything misleading, anything other than what happened. And so while I appreciate that the court below didn't reach the merits, and perhaps the procedural orders were form over substance, we certainly requested that the judge below take the bull by the horns, address the merits, and the courts are gatekeepers under the statute as to decide whether any eviction can go forward. You got to get through the court, you got to get through the clerk, you got to then prove that what happened amounts to something that is outside the definition of a non-essential eviction. Of course, we never got there. And then you have to get to it, and then the process servers are also in there as a gatekeeper. And under the statute, the division of, the Executive Office of Housing and Economic Development is another entity that's charged with issuing regulations. And of course, there's the requirement of the landlord or his counsel, which is myself in this case, putting in an affidavit, attesting to the fact that this is not an eviction, barred, foreclosed, can't even be filed. So when the judge issued that, said that I do find that it's for cause, in my view, what that was is, look, this is something that gets through that gatekeeper. So think again if you really want to go down the path of suing under the moratorium. He didn't find that we were entitled to possession because we never got there. So unless the court has any further questions, we would request that the court affirm the dismissal, but rule that it's for cause, with prejudice, and end the litigation conclusively. Thank you.
All right. Thank you both very much for your argument.
We are live and on the record.
All right, our final case for today is number 21P459 in the matter of Stephen R. Simpson. Attorney Trainee, I think we'll hear from you first.
Thank you, Your Honor. Good afternoon, members of the panel that please the court. My name is Rosemary Trainee, and I represent the appellant, John McCormick. This is a request for to strike the to overturn the probate court's decision to strike Mr. McCormick's appearance in the Simpson probate. And essentially, Your Honors, what our position is that the documents that were submitted on behalf of Mr. McCormick were sufficient to satisfy the statutory requirements of an affidavit of objection. And that we base that on the fact that what was provided were certified copies of various documents that were signed under oath or that were otherwise notarized, and that we combined that with an opinion of an expert who had opined that the signatures on the will were not Mr. Simpson's signature.
Well, where the purpose of the affidavit requirement would seem to be, at least in part, to ensure that the factual grounds for the objection have some merit. Does it matter that the expert's opinion itself was not in affidavit form?
I don't think that it does, because I think that it's an opinion of an expert, and it's obviously her opinion. It's submitted as a written opinion with all of the specifics to it. I don't think that the fact that it's not notarized should negate the fact that it's putting forth to the court something more than simply a lay person not believing that a particular document was signed by the person who purported to sign it.
But when an expert testifies in court, the expert still has to take the same oath as everybody else, and presumably that's some insurance that the person is telling the truth. Now, I'm not suggesting there's any reason on the face of the opinion to think the expert wasn't giving her honest, good faith opinion, but we're talking about a question of law here, whether the affidavit requirement should be enforced as a general matter.
Yes, I understand that. But I do think that based upon the expert's opinion and coupling that with the certified copies of documents that had been notarized or were otherwise under oath, that those two things together, I think, satisfies the requirement, at least, that the purpose of the affidavit is to weed out frivolous claims. And I think for any expert to sign a report or an opinion stating that they believe that the signatures on the will were not the signatures of the decedent, it goes well beyond what any layperson could provide in an affidavit of an objection. And I think that when you look at the cases and you look at what the reason for the statute, I think that having the expert's opinion notarized or not gets you beyond that hurdle.
You say when you look at the cases, am I correct that there are no cases in Massachusetts about whether there needs to be an affidavit if the grounds for objection might be otherwise sufficient but weren't signed under the pains and penalties?
I did not find any case that specifically says that. The only cases, and I found no cases that relate to a situation where you're talking about a purported forgery. I was only able to find one case wherein the judge made a comment that she was not an expert in handwriting and was therefore going to not render an opinion and put it to a trial and have the experts testify. So I was not able to find anything that talked about whether or not in such a situation the affidavit could be satisfied. The affidavit requirement could be satisfied by putting together other documents that are sufficient to make a statement under oath. And
Attorney Trainee, can I'd like to pick up on another aspect of the sort of, I'll call it the gatekeeper function of the affidavit requirement, which is that the person who's coming to court actually has some legal entitlement to be there in that case. It wasn't until after the 30-day deadline had passed that your client submitted anything to the court in affidavit form saying that he had the legal right to be there, that he had been assigned the claims of the siblings to the decedent. Why is it enough for us to consider that he is properly before us, that he submitted this thing after 30 days, and also, if memory serves, it's his bare assertion. There's no document, there's no additional supporting information that we could look at to see whether he's properly the guy who can bring these claims.
I don't, at least in my reading of the statute, and the cases, it's the status of who's making the objection isn't the driving force. And in this case, he was represented by counsel. First of all, he wasn't in as pro se, making certain assertions. And I also think that I don't think that the purpose of the affidavit is to solidify what your relationship to the estate is. The purpose of the affidavit is to see whether or not there's a valid claim to challenge the will.
Well, but I'm not sure how you can distinguish. There might be very good reasons to think that this will is a forgery. I'm just speaking hypothetically.
Mhm.
But if the person who is asserting that it's a forgery has no right to challenge the will, then what does it matter? I mean, just as a complaint, civil complaint in any civil case needs to establish that the plaintiff has standing as well as a claim on the merits. Doesn't the affidavit here need to establish that the objector has standing to object as well as a basis to object? Otherwise, why should the court spend its time on the merits of the objection?
I don't read the statute as saying that's what the objector has to do. I think that I read the statute as saying the objector has to prove that there's a valid issue or a valid claim, but not that that they have to necessarily provide documentation that they are the claimant. And I don't think that was what was raised in the case. It was more that that there was no affidavit. I know that there was some argument raised at the hearing about the fact that my client was a stranger to the estate who was trying to get access to the property. But I don't think that should be the driving force as to whether or not the other documents together make a valid claim as to whether or not the will was a forgery or the signature was a forgery.
Mr. Gallagher, or Ms. Gallagher, I should say, argues that we don't have jurisdiction over the appeal because the notice of appeal, as I understand the argument, didn't list the final order admitting the will to probate. What's your response to that?
My response to that is that I do think the appeal was timely. They don't cite any authority for that statement other than that.
I didn't take them as necessarily objecting to timeliness, but rather that you didn't object. The notice of appeal doesn't name that final order, and I may be getting the name of it wrong. The decree and order of formal probate, 11/13/20. Your notice of appeal was filed after that, and certainly within 30 days, but it doesn't list that as one of the orders that you're challenging. Does that matter? Or if we were to vacate the order striking the objection, would that be sufficient to open up the whole matter?
I believe that if you vacated the judge's allowance of the motion to strike, it would reopen that, because I think that one of the decisions that we had also made was not to necessarily do anything detrimental to the estate. And I also think that once the motion to strike is done, we're out at that point. Once our appearance is stricken, we're no longer a party to the case from that point forward. So from the date that happens, which was before the final allowance of the appointment, I think that's what we have to look at is what happened the day that the motion to strike was allowed. And at that point, we're literally banned from the case. So that's what we have to appeal. And so I think that's where our appellate rights rest at that point. I don't think we can appeal something that happens after we're stricken from the case. And so I think that if we're successful in the appeal overturning the motion to strike, then I think that reopens the issue of the appropriateness of her appointment as the personal representative. As your honors are aware, this is a very limited issue, and other than what's already in the brief and the fact that, as again, I don't want to beat a dead horse, so to speak, but the the issue is that we think that what was submitted was sufficient to allow the judge to let the matter go forward to an evidentiary hearing and was not in derogation of the statute. Thank you.
Could I just ask this? Would the purpose of the evidentiary hearing be to establish under oath the same things that would have been established in an affidavit? Or was there some other purpose for the evidentiary hearing?
Oh, I think the purpose of the evidentiary hearing would have been the experts and the analysis of the documents and whether or not it was a forgery.
Thanks.
Thank you.
Thank you. Attorney Brennan.
Yes, thank you, Your Honors. May it please the court. Edmund Brennan representing the appellee. As the court is well aware from its interaction with the appellant, the main thrust of our defending this appeal is that the statute is very clear. It requires the filing of an affidavit within the 30 days after the filing, after the return date. It's undisputed and has been admitted by the appellant that that was not done in this case. There is no authority in the Commonwealth or elsewhere that I found that would allow an assembly of unverified documents to arise to the effect and the role of the affidavit, which is critical to this rule. It's not a rule, it's a statute.
And just to be clear, you didn't find any cases to the contrary either, saying that it would not.
Well, I did not find anything to the contrary. However, I don't think that the argument by the appellant that a certified copy, no matter how many certified copies they might stack upon each other, arises to an affidavit. A certified copy is simply a document that says it's a true copy of another document, and it doesn't validate the content of the document. So the argument that certified copies assembled together could arise to an affidavit, I think, fails under the definition of affidavit cited by both sides through Black's Law Dictionary.
So if the opinion of the handwriting expert had been in affidavit form and had attached these various copies of the court documents and other filings, would that have been sufficient?
I believe, yes, that would have got them over the hurdle, because the affidavit can be by a third party. The affidavit need not be by the actual objector. I think the case law is clear on that. However, as we sit here today, we don't know.
What case says that, just so we can make sure we're taking into account?
That's in my brief, Your Honor. I believe it was the.
I saw there was some observation or a note that an affidavit by a third party had been filed, but I think, as you said in your brief, the case itself was resolved on other grounds.
Correct, but I think it validated the affidavit by a third party. And in fact, in the rules of civil procedure, which aren't before the court on this case, but Rule 11 allows verification on behalf of a party by a third party on the filing of pleadings. However, it has to be an affidavit form. So I think the rules allow it. And one of the cases cited in my brief, Your Honor, which I apologize, I can't direct the court to specifically which one, references affidavits by third parties. So it need not be by the objector, but nothing, all of the requirements are of an affidavit. There's nothing that would validate a certified copy arising to an affidavit under the definition that both parties have agreed to.
The statute says objecting party shall file a written affidavit of objections stating the specific facts and grounds upon which the objection is based. Does that need to include the facts that give the objector standing?
Oh, I believe so, Your Honor. Otherwise, you could simply file an appearance and an affidavit by any person off the street and then claim to contest a will. The standing, it can be challenged and raised at any time as it's a jurisdictional issue. In this case, it's rather unique. I mean, if it was an heir at law that was challenging the will, then the standing would be inherent in their status as an heir at law or a devotee or a beneficiary under a will. This is a stranger to the estate, so I think it's even more irrelevant that that person prove their right to be before the court.
If there had been an affidavit and perhaps accompanied by a copy of an assignment saying that the deceased's siblings had assigned their rights under the will to Mr. McCormick, would that have been sufficient to confer standing?
I believe that an interest in an estate may be assigned. I spent quite a bit of time looking for something to say that that would not be the case, but I didn't find anything. It's a property interest, and I believe it may be assigned. However, as we sit here today, we don't know whether, if there is an assignment, and if there is one, we don't know what it says. It could be conditional. It could have restrictions set forth in that document that would knock them out of being a party to this case. It's all speculation. The assignment has never been produced, if it even exists. It's similar to the affidavit by their purported expert. We don't know whether that person would be willing to sign that opinion under the pains and penalties of perjury, because it wasn't. And we would have to speculate on that issue, which I think are two roads that I would ask the court not to go down. The assignment is speculation as we sit here today, Your Honor.
You said you've tried to characterize the filing requirement as jurisdictional, and jurisdictional usually means non-waivable by the tribunal and not waivable by the opposing party. Just imagine a situation where there's an objection and the proponent of the will wants the objection resolved, perhaps because it's raised some issue of, intrafamilial conflict, and the objection was filed one day late. The proponent wants to waive that 30-day requirement so that the objection can be resolved on the merits and lay this family dispute to rest, rather than having it discarded or dismissed based on timeliness. Could the objector not do that? I'm sorry, could the proponent not do that, and could the court not accept it?
I don't think the proponent could, Your Honor, unilaterally. It's similar to where a personal representative cannot pay debts of the estate outside of the time in which the claims may be made. The parties can't agree to confer jurisdiction. Now, if I were confronted with that situation, I would say it could be done if all interested parties to the estate joined in the settlement agreement. But I don't think a personal rep could unilaterally do that. I think it would be a breach of the fiduciary duty in an attempt to confer jurisdiction where there isn't any. I think it would take all the players.
But we don't have to agree that this requirement is jurisdictional in order to affirm the court, I take it. I mean, the statute says an objection with the affidavit of objections must be filed within 30 days. Whether we say that's jurisdictional or not, is that essential to your argument?
I think your review is a question of law of how Judge Roberts' action on the motion. So she allowed my motion in which I claimed the 30-day statute of limitations, or the 30-day statute, and she agreed with that and allowed the motion. So I think implicit in that is that the party was not properly before the court, and therefore the court didn't have jurisdiction over the issue because the party wasn't appropriately before the court. Had an appropriate party been there, certainly the court would have jurisdiction over the issue.
All right. I'm not seeing further questions from my other justices on the panel. And unless you have anything further to say, Attorney Brennan, we'll leave it there.
I think I've covered, Your Honor, what I wanted to, and I thank the court.
All right. Thank you both very much for your arguments. That concludes our session for today, and we thank the court staff for their assistance in making the session happen.
Thank you, Your Honor.